Congratulations to all of the nominees. Thank you all for being here. Judge Bezos, if I could just start with you. I want to ask you about this case, United States versus Bartunik, I think it is, from 2017. Do you remember this case?
I do.
This is a case in which you granted pretrial release to the defendant. It was a child pornography case. Does that sound right?
Yes.
Now, you said in your responses to the panel's questions that the defendant had no criminal convictions and had lived in Nebraska his entire life, and that he owned the home he was living in and was employed. I understand, however, at the time that you granted him release, the Omaha Police Department had an open investigation regarding the sexual assault of a 7-year-old child in which he was the subject. He was the suspect, and that was in the pre-sentence report. So just walk me through your thinking.
During the hearing, I asked for additional information from the government, and they couldn't give it to me, so we didn't have a lot of facts in regards to that. The facts and circumstances, there was no additional information that was provided to me at that time.
So you didn't know he was the subject of the investigation?
There may have been a mention, but the question I had was, well, what does that mean? Has there been a report made? Is he truly the suspect, or was his name just mentioned? What were the circumstances? And at that point in time, there was no additional information that could be given.
I see. So it looks like to me what was, according to the revised PSR, the Omaha Police Department has an open investigation regarding the sexual assault of a 7-year-old child, who's then identified with initials, in which the defendant is the subject. But you're saying that you thought that was not sufficient in order to guide your judgment?
Was that the pre-sentence report, which would happen after sentencing, versus the pretrial report, which is what I would get prior to bond setting?
Offers the following objections to the revised PSR. The defendant objects to the inclusion of any reference, and then it goes on to quote this material about the sexual assault. So you're saying you didn't have that information?
Correct. That would have been after sentencing.
Okay, so you weren't aware that...
At sentencing, prior to sentencing after a plea, is when that information would...
Okay, so when you granted pretrial release, you were not aware that he was under investigation for the assault of a 7-year-old?
Based on what you're saying in that PSR, then no.
Well, I'm asking, is your memory any different? I mean, I can give these questions to you for the record if that would be more helpful. I just want to clarify the facts, because I just want to make sure. If you're telling me you didn't know about it, that's a very different thing.
Well, I don't believe I did.
Okay.
But
okay. I tell you what, I'll give you some questions for the record on this, and that way, so that you don't have to just rely on your memory.
And I can go back and look at the pre-sentence report.
That'd be great.
Or the pretrial report, which would tell me that.
Great. Fair enough. Thank you. Judge Merriweather, let me just ask you in my short remaining time here. I think Senator Kennedy was asking you about this case, United States versus Johnson, where you recommended the release of a sexual predator to get medical treatment. Is that right? Do I have the right case?
Senator, I recommended a 21-day a temporary release for medical treatment after holding multiple hearings and giving the government multiple opportunities to get Mr. Johnston to his appointments, because as I noted in the opinion, I thought the charges were deeply disturbing. I take very seriously the danger to the community, and I found when I balanced the 4 factors that I had to consider under the Bail Reform Act, that it was only his history and characteristics, which was that at the time that issue was before me, he had an urgent need for diagnostic and treatment, cancer treatment.
Let me just say, I'm sorry to interrupt you. I'm almost out of time. I just want to make sure I understand the sequence, because I might, as to my questions with Judge Bezos, I might not have the sequencing right. So just, you can correct me here. So I thought the government filed an emergency appeal of your release order, and you were overturned by the D.C. District Judge because, for among other reasons, the predator here had been caught in a sting operation. He'd admitted to sexually abusing his 8-year-old daughter. He had been previously court-martialed for molesting a child when he was in the Air Force. That child was his adopted daughter, and he claimed to have sexually molested other children, and the government thought that releasing him was a terrible idea. The district court agreed with him. Agreed with the government. So I just wonder, in light of all of that, as you look back on it now, do you think it was a bad decision to recommend release for him?
Two things. First, all of the abuse that it was alleged was horrific. The charges that were in front of me did not involve the molestation of his daughter, which I believe had happened 15 years earlier. And my decision was not based solely on the nature of the charges. That's but one of 4 factors that the Bail Reform Act required me to consider. The factual predicate, as I highlighted in that opinion, I found it very challenging to even entertain the idea of releasing someone charged with such heinous crimes, as well as someone who had a history decades earlier of abuse. But I found that his own interest in self-preservation paired with stringent conditions, being under the custody of his wife for a limited period of time and only allowed to leave his home to go to the doctor in order to get the timely cancer treatment that he needed, that despite 3 opportunities he was unable to get through no malicious intent of the government.
Can I just ask, this is it, Mr. Chairman, this is my last question. Can I just ask, I thought that he was getting cancer treatment, but your judgment was he wasn't getting enough or the right kind, but he was getting treatment. Is that not accurate?
No, that was the change between my ruling and the time of the reversal. I gave the government 3 opportunities to take him to the doctor, and I kept him detained despite it. He did not get to the doctor. I ordered him temporarily released so that he could see a cancer specialist, because cancer is a time-sensitive issue, as many of us know, with loved ones who are survivors of cancer. And then the next day, he got to the doctor. Had he been to the doctor, I would not have released him for 21 days. I didn't feel that he needed a specific doctor, which was the facts that were presented to the district judge. It was that he see any doctor so that he could timely have his cancer addressed. Unfortunately, that did not happen before he saw me, so I made the very difficult decision of ordering temporary release under stringent conditions so that could happen. It then happened, and so the need for it no longer existed. Had he seen the doctor before I ruled, I would have denied his motion, and I would have ordered that he remain detained.
Thank you for that explanation, Judge. I just note here in the notes, when you disclose this,
Mr. Chairman.
Senator Hawley.
Thank you, Mr. Chairman. Congratulations to all the nominees. Thank you for being here. Mr. Ali, if I could just come back to you, I want to follow up on what Senator Graham was asking, because I didn't hear all of your answers. I just want to make sure that I understand where you are on these issues. So just to set the table here, you're the president and executive director of the MacArthur Justice Center. Is that correct?
Senator, that's correct. I have one other disclosure for you, which is that I'm also a 49ers fan.
Oh,
and
no.
So I'm just
Starting
apologizing in
late.
advance for what Christian McCaffrey and Deebo Samuel will
Trash
unleash
talk.
on your
Oh, my
Chiefs
gosh.
this Sunday.
Oh, my gosh. Here we go. All right. I'll come back to that. So let's just clarify some things you said to Senator Graham. So your organization, the MacArthur Justice Center, has expressed support in the past for the defund the police movement. I'm looking here at public statements, public comments that the organization has made, calling for defunding the police, hashtag defund the police. Here's one. Here's the second one. I know you're familiar with these. And I thought I heard you say to Senator Graham that you disagree with this, that you do not support defund the police. I just want to make sure I got that right.
Senator, that's right. I have never taken that position, nor would I, for any number of reasons. One of which I'd like to say is that I work closely with law enforcement on these issues of accountability, public safety, and confidence in law enforcement.
Okay, good. So to the extent that the center has in the past taken this position, that does not reflect your views and doesn't reflect your leadership. Is that fair to say?
That's right. So much so that I looked into that and tried to figure out how that hashtag, I understand there was an article describing 2 tweets that had been made, looked into that and I'm still to this day puzzled how that happened, but they were before my time as executive director.
Well, you say puzzled why the center expressed those views? Is that what you're saying?
To my knowledge, the center itself has never taken the position of defund the police.
Okay, and you disagree with that position. You disagree with the defund the police position. Okay, let me ask you about something else I think Senator Graham was touching on. My understanding is that the MacArthur Center asked the Chicago State Attorney's Office to dismiss all the charges against rioters following the BLM riots in the summer of 2020. Do I have that right? And if so, do you agree with that?
Senator, my understanding of that circumstance is that the attorneys in that office, I wasn't a part of that office at the time, represented individuals who were peaceful protesters and represented community groups. And so that letter took place in the course of advocacy that I wasn't personally involved in, so I'm not intimately familiar with the fact.
Okay, you would not support, though, dismissing charges against rioters who committed acts of vandalism, violence, etc., as a general matter?
Senator, I believe that people who are a risk to public safety need to be accountable and need to be held pending those charges if they're a risk to public safety. And I understand the law to require that. Let
me ask you, since you said pending, my understanding is the MacArthur Center also opposes pretrial detention. Is that right?
Senator, so let me be very clear. I believe that if somebody is a risk to public safety, they should be held. And federal law requires that. The Bail Reform Act requires that, in addition to some other considerations. And if confirmed to be a federal district court judge, I would apply that law without reservation.
So I got you. So just the center, though, am I wrong? They don't oppose. Your center does not oppose pretrial detention. Am I wrong about that?
Senator, there's no categorical opposition to pretrial detention, as I understand it. The United States Supreme Court has been very clear that someone cannot be detained solely on account of their poverty. But to my knowledge, the Justice Center's position has been that if someone is found to be a risk to public safety, then detention is warranted under the law.
And what about the use of electronic monitoring of defendants? Does the MacArthur Center oppose that?
Senator, again, my understanding of federal law is that the supervised release provision.
Well, but I'm asking about the center, though. I'm familiar with federal law, but the center that you're the executive director of, I just want to clarify. I want to make sure I understand what your positions are.
Yeah, I appreciate that, Senator. So I haven't personally worked on a case involving electronic monitoring. I can tell you that the center is not a policy organization. We don't have a single employee in our organization who takes policies. All of our work is grounded in litigation, in a client.
Okay, let me ask you, I don't mean to interrupt you. I mean, I do mean to interrupt you, but I don't mean to be rude about it. I'm almost out of time. But let me just ask you this. The director, as I understand it, of your Illinois office referred to electronic monitoring as replacing one form of incarceration with another. Does that reflect your views or the views of your organization? How about, does it reflect your views? Let's just get to that.
Senator, I'm not sure I fully understand what that would mean under federal law. I can tell you that the Bail Reform Act, the Sentencing Reform Act, and the supervised release provision require supervision in certain circumstances, first and foremost, when there is a risk to public safety and a need to protect the public.
Well, my time's expired, and I know that there are other colleagues here who want to ask you questions. I appreciate your answers. This is helpful. My concern has been that the center that you're the executive director of seems to take positions to me that seem, frankly, a little extreme. So maybe those aren't your positions. I'll give you some more questions for the record. I was so nice to you, even though you're a 49ers fan. It's horrible. But the Chiefs, I know I was really nice. The Chiefs are going to win by 10, at least. Thank you, Mr. Chairman.
We'll watch together.
Without objection, we're going to enter into the record a letter sent in support of Mr. Ali's nomination. Thanks, Senator Butler. Senator Hawley.
Thank you, Mr. Chairman. Congratulations to the nominees. Thank you for being here. Congratulations to your families. Ms. Sugnanan, if I could start with you. I think we've established from the recent lines of questioning that you worked at Jones Day. You were a partner at Jones Day. Is that right?
That's correct, Senator.
And how long were you at Jones Day, out of curiosity?
I was at the firm for 6 years, Senator.
Okay. You had a series of clients in that time, I imagine. Is that fair to say?
That's correct.
That included a series of hedge funds, global hedge funds. Is that right?
Yes, Senator.
Funds like Altair Global, Claren Road Asset Management, Glendon Capital Management, Nakota Capital, Oak Tree Capital Management, Oker Rose, and Centerbridge Partners. Does that sound right?
That sounds right.
And you represented these hedge funds in particular during a debt crisis that Puerto Rico had in 2017. Do you remember that?
Yes, Senator.
So Puerto Rico had a debt crisis in 2017. Your clients had bought a series of bonds and held quite a lot of money in bonds, if I'm correct. And it's $1.4 billion. Does that sound right?
Yes, Senator.
Of course, other people had bought bonds too. Normal people, everyday people had bought bonds. And when the debt crisis kicked off, the courts froze all of the assets, all of Puerto Rico's assets, to make sure that everybody got their fair share and was paid out in accordance with the law, and that normal people who bought bonds would get their fair share, right? I mean, I've got it right so far?
Yes, Senator.
So you, however, on behalf of your clients, you invented a novel claim. You filed a lawsuit under the takings clause. Is that right?
That's correct, Senator.
So you argued that the government was stealing from the hedge funds by freezing all of the funds, and if they pursued that course of action and didn't give your clients all of their money first, then they would have violated the U.S. Constitution. Is that right?
That's not quite correct, Senator.
Why was it a good idea? Why represent all of these hedge funds trying to get billions of dollars out of Puerto Rico when other everyday bondholders are left to pick up the slack? You dragged this thing out for years. I mean, you went back and forth to the circuit court. Other hedge funds then followed your lead. They thought that was terrific arguments, super inventive. So then they did the same thing. So then other hedge funds piled in. The bankruptcy went on and on. Puerto Rico was forced to institute serious austerity measures, much to the detriment of their citizens, average people who don't have money for hedge funds. Why is it a good idea to go to Puerto Rico and to try to get your rich clients prioritized over normal people in a way that seriously impoverished, if I might say, the citizens of the island?
Senator, the legal profession is bound by a code of ethics that I think is incredibly important and that I am proud to adhere to in every case. My clients in that case...
Take from the rich or take from the poor to give to the rich? Is that the code of ethics?
Senator, Jones Day was retained in that case to represent a group of clients. Along with my colleagues, I made the best possible arguments.
Well, wait. Are you saying it wasn't voluntary? You represented them, right? You were lead counsel, I thought. Were you lead counsel?
Senator, I was not lead counsel. I was one of many lawyers who handled that litigation.
And it was involuntary? You were assigned, or you chose to do it? You did it voluntarily, didn't you?
Senator, those hedge funds were a client of the firm. I was asked to join the team and work on that matter.
Which you did. Okay. My question is why? Why is that? Why is it a good idea? I mean, you can say no.
Senator, my colleagues and I at Jones Day in that case made the best possible argument.
Well, I know, and I listen. I don't doubt. I'm not questioning your talent. I understand why they wanted to hire you. Your talent's considerable. I'm just wondering why you thought it was important to deploy it on behalf of these hedge funds to the detriment of everyday citizens who were bearing the cost. And you invented it was very novel. Listen, I give you credit. And everybody else thought so too. That's why all the other rich players got in and said, we want to do that, and drug it out for years. I'm just wondering why you thought that was a good idea.
Senator, Jones Day was retained to represent
I heard that the first
clients.
time. I'm just wondering why you thought it was a good idea. You could use your considerable talents in any number of cases, ways, means, and methods. You could have said no to representing these clients. You didn't, obviously. In fact, you vigorously defended them to the point of inventing this novel theory, which was quite successful for your very lucrative clients. I'm just wondering why.
Senator, I have represented a number of clients over the course of my career. I have represented the government. I have represented clients.
So you don't have any problem with this? You think this is a good idea? You stand by it?
Senator,
No
my
regrets?
job in that representation was to vigorously represent my clients, which I did.
Sure, but we'd established, I think, a second ago, I thought you told Senator Kennedy that you resigned from Jones Day over a client that the firm was representing who you didn't like.
Senator, that is not at all what I said.
You didn't resign from Jones Day?
Senator, I did not resign from Jones Day because of any particular representation.
So it wasn't a moral, you had no moral quandaries?
Absolutely not, Senator.
You had no moral quandaries with any of the cases at Jones Day? That's your testimony?
Senator, I left the firm in January of 2021 because I was offered an opportunity to return to public service. It's an opportunity the firm supported and that I took.
You had no quandaries with them representing in the Trump litigation. You had
Senator,
no problem with that. That's your testimony.
Senator, I did not leave my firm because of that representation.
You had
I
no
left
moral
my
problem with
firm,
it.
Senator, I left the firm months later because I received an opportunity to
You
return
had no problem
to
with
public
that, and you
service.
had no problem representing the bondholders. So your testimony is you're happy to represent anybody who comes your way. Donald Trump, you bet. The bondholders, you bet. Hedge funds, you bet. Whoever. That's your testimony? I just want to make sure I got it right.
Senator, throughout my career, I have adhered to the code of ethics that all lawyers are bound by.
Well, sure, but the code of ethics allow you to make money from anybody. Listen, you can choose your clients. I'm not accusing you of any ethical violations at all. I'm not. I'm just trying to figure out why you thought it was important to have these hedge funds as your clients, and if you had any moral quandaries. And your testimony is you didn't have any moral quandaries, which is fine, but I just wonder if that's the best judgment.
Senator, throughout my career, I have represented corporate clients. I have represented criminal defendants. I have represented the government. Throughout my career, I am proud that I have
Want to say anything to the
fulfilled.
people of Puerto Rico while we're here?
Please let her finish the answer. Your time has expired. Go ahead.
Thank you, Chair Durbin. Throughout my career, I have represented many different clients. I am proud that in every representation, I have made the best possible arguments for all of my clients.
Do you want to say anything to the people of Puerto Rico?
Senator Whitehouse.
Thank you very much.
Quite confused about this ethics issue or issues. So maybe you can just help me sort it out. So I don't think I maybe understand the facts here. So you said that you've never been subject to an ethics complaint before. Is that right?
I said, to my knowledge, never been subject to an OPR complaint or any sort of formal complaint.
Okay. I'm looking at a letter from May 16th, 2010 to the Office of Professional Responsibility that reads, this letter is a formal request that your office investigate matters pertaining to the fair dealing and, more important, honesty of Assistant United States Attorney Kevin Ritz.
If that letter exists, Senator, I was unaware of it until just now.
But you're aware of the issues surrounding the Von Rico Weber case, which is the subject of this letter asking for a formal investigation into you. You're aware of that?
As I said, I do have some recollection of that matter.
Oh, okay. So you were subject to a complaint. I have the letter right here. Let's just try to figure out what's going on in this case. I mean, this was a case involving a public defender who you got a plea agreement with, and then she asked to withdraw as counsel because she said you misrepresented the situation to her, and the court granted her motion to withdraw as counsel. That's pretty unusual, isn't it? I mean, what's happening here? She said that you told her that she relied on information about the nature of the crime, which was, she was told, was going to be a marijuana trafficking offense, and then when she got the PSR, it had a base offense level of 34 because the underlying offense was cocaine trafficking. So she had advised her client, based on your representations, here's what you're going to be likely subject to. They accepted the plea deal. She looks at the PSR, and it's something very different, she says, than what you told her. Now, this is a public defender now. And so on that basis, she had to withdraw as counsel, and the court granted her request. That's very unusual. I mean, what happened here?
Senator, first of all, I believe it was not a public defender. It was a defense attorney on the CJA panel in West Tennessee. There was a written plea agreement that was entered into. That written plea agreement, as with all of our plea agreements, includes a provision that says these are all of the promises made to this defendant by the government.
Yeah, but neither the indictment nor the change of plea transcript nor that agreement says anything about the underlying crime. It just says funds were the proceeds of distributing controlled substances without any specification of the alleged illegal narcotics. So what she says is, you sandbagged her, basically.
And that's not true. I made no such promise along those lines. It's
but
not
was
true.
there any indication before the PSR that you were going to hit this guy with a cocaine? I mean, this is unusual. It's unusual to be a Democrat administration nominate somebody who is accused of, who's hated by federal public defenders, and who's accused of sandbagging indigent defendants. So I'm baffled by this. I am totally baffled by this. So I'm trying to figure out what in the world happened. And then you got taken off this case, I think, right?
My recollection, Senator, is that the office had someone else handle it in case I needed to be a witness at a proceeding.
Well, here's what Vivian Donaldson, who is the counsel who ended up representing the United States, at Ms. Chastain's motion to withdraw as counsel, here's what she said. These allegations about you are serious. That's one of the reasons I am here, meaning in court, and Mr. Ritz will more than likely be taken off this case because of these particular allegations. So did that happen?
And again, I believe it was in case I needed to be a witness. But those allegations.
This is what your supervisor said in open court. I'm not quoting you now, a private letter. I'm quoting you something from open court. She says you were removed from the case because of the allegations, which she says were very serious. Now, you've represented this committee. You knew nothing about all of this. You answered a question in the committee questionnaire that you weren't aware of any complaint. You weren't aware of any disciplinary committee. You weren't aware of any inquiry ever. But yet, I'm reading you a transcript from open court in which your supervising attorney says the allegations against you are very serious and you're going to be removed. So I have to tell you, I don't think I'm trying to figure out what in the world is going on here, because it doesn't sound to me like you've been very forthcoming, certainly to this committee. So what happened? Were you removed because of the allegations of improper behavior?
The allegations were false, first of all.
I'm not asking you about your view. I'm asking you about what you told the court and about what your supervising attorney told the court.
And I don't recall exactly why there may have been a change in counsel.
Mr. Ritz, don't you think you'd want to, don't you think that's kind of important information?
These allegations were false, and there was never a finding.
You have a clear memory of that, but you don't have a clear memory of what happened in open court and you being potentially removed by your supervising attorney. This is very bizarre, I have to say. I've never seen it quite like this. This is very, very strange. And I just noticed that we have a sudden instance of amnesia anytime we're dealing with the actual ethical complaint, but you seem to remember the case exceptionally well. So this troubles me, and it's strange. It's very, very strange. Maybe my Democrat colleagues can clear this up. I'm sure they've vetted you. This is very, very odd. So your testimony is you weren't removed. All of this was false. You were never investigated, and this just all went away, or what happened?
There was certainly no court finding or any other finding by an investigative body of any unethical behavior.
I thought the court then allowed this defendant to change his guilty plea. He pled guilty, and then the court allowed him to withdraw it. That's also very unusual.
It does happen from time to time, Senator.
On the basis of your misrepresentations.
And that was not the finding of the court.
Thank you, Mr. Chairman.
Senator Whitehouse.
Welcome to the committee, Mr. Ritz.
Thank you, Senator.
Thank you very much, Mr. Chairman. Congratulations to the nominees. Thank you for being here. Ms. Johnson, if I could just start with you. You work at a large corporate firm here in town, I think. Is that right?
Yes, Senator.
You, according to the materials you submitted, you have represented, among other clients, the Boeing company since 2013. Do I have that right?
That's correct.
According to the same materials, for much of this representation, you served as the primary or the lead counsel for Boeing. Is that correct?
In certain matters, I did.
Is that litigation still ongoing?
No, it is not.
There's a case in particular I want to ask you about. It's a case that featured breach of contract claim, fraud claims, and trade secret claims by a company called Alabama Aircraft Industries. They allege that Boeing stole proprietary information when the two companies were working together on a joint bid for an Air Force contract. Now, a federal jury had already determined that Boeing owed this company $2.1 million for violating the bidding contract and for breaching a non-disclosure agreement. Boeing had previously, in 2006, paid a $615 million settlement to DOJ to settle claims that it had illegally obtained competitors' information with lucrative government contracts. And as I'm sure you're aware, Boeing has been at the center of major, major concerns about whistleblower retaliation, safety of its planes. In fact, we've heard testimony right here in this committee about all of that. Here's what I'm getting at. Boeing has engaged in corporate behavior in a pattern going back years now that, shall we say, is less than model. Do you have any thoughts about your representation of this company? Any regrets, any concerns?
In my work as an advocate, I have been duty-bound to zealously advocate for my client's best interests, and that is what I have done. As a neutral judge, I am very mindful that my role instead would be to apply faithfully and impartially the law to the specific facts that appear before me, and that is what I would do.
No moral qualms at all?
I believe that it has always been a strength of mine to be able to see the shared humanity in every one of my clients, no matter the issue. And I understand that as a judge, my role would be to fairly and impartially apply the law, no matter the parties or the issue that was before me, and that is what I would do.
Well, shared humanity, this is a corporation though, isn't it? It's one of the biggest corporations in the world.
It is.
And one of the most profitable corporations in the world. I assume you chose to represent them voluntarily. I mean, right? You weren't forced to represent Boeing.
It was the case I was assigned to at my firm.
But you continued to do it. You served as lead counsel, I thought. There's multiple pieces of litigation in which you served as primary lead counsel for Boeing, correct?
There are multiple Boeing matters that I've handled.
Yeah. Okay, let me ask you about a different corporation that you've represented, the 3M Corporation, huge multinational conglomerate. In this case, the plaintiff was an individual named Jonathan Vaughn. He was an Iraq War veteran. He alleged that he'd suffered hearing loss stemming from his use of defective earplugs manufactured by your client. Vaughn was awarded $2.2 million in that case. Here's a report from the case. The jury decided that 3M's earplugs were to blame for his current hearing impairment, while also determining the earplugs were unreasonably dangerous, according to the verdict form. 3M misrepresented the quality of the earplugs and was negligent in their design. The report goes on to note that at the time of this verdict, this was the 9th of 15 cases against 3M to go against them in litigation over these earplugs. Just any conclusions or reflections on your involvement in that case?
Senator, I've had a varied practice handling cases that span the spectrum of legal issues and representing a wide range of parties throughout my career. And I believe that the litigation matters and the variation in the work that I have done has given me a very strong and versatile litigation skill set and a comfort in the courtroom that would serve me well were I to be confirmed to be a judge on the D.C. Supreme Court.
Okay, so you're not concerned is what I take from it. I mean, you don't have any regrets about representing either of these corporations in these various matters.
I believe that I have had a strong litigation practice throughout my career.
Well, I heard that part, but I'm just asking if you have any regrets, if you have any qualms. Sounds like you don't, which is fine. I just want to. I mean, obviously you're a very talented person. You've done terrific work. You were made partner at a very early age, so you have a lot of skill. I'm just trying to figure out why you've chosen to use it for these particular clients.
I do not have regrets about my career. I believe that I have developed a strong litigation skill set that would serve me well as a judge.
Okay, fair enough. Fair enough. I have concerns. Obviously, I don't love the representation. These big corporate clients, these huge corporations, they've got so much influence in this capital. They've got so much influence in our economy. They've got probably every law firm in America lined up to represent them. And, I just think sometimes we got to ask ourselves, I mean, do these people doing these kind of things or ripping off people like Jonathan Vaughn, I mean, do they really need our representation? Obviously, every client's entitled to a vigorous defense, sure. But we still have to ask ourselves, I'm an attorney myself, we still have to ask ourselves as attorneys, should we be representing them? I mean, do we want to do that? Obviously, it's your judgment, so I'm not suggesting you've done anything wrong. I mean, it's 100% your judgment, and you did your job well. But I have to say, it concerns me a little bit. I'm almost out of time. Mr. McKenzie, I just want to ask you one thing really quickly here before my time expires. You wrote a letter in 2021 asking then Vice President Pence to invoke the 25th Amendment. I just want to quote you to make sure I get this right. You asked, that's the removal from office provision, the unfitness from office provision of the Constitution. So you urged then VP Pence to invoke the 25th Amendment against then President Trump to declare to the leaders of Congress that the president's unable to discharge the powers and duties of his office. You went on to say that then President Trump was unfit for office and a reckless and wanton threat to the Constitution. Does that still reflect your views?
Senator, I do want to correct the record. I didn't write the letter. Along with hundreds of other folks, signed on to the letter because we were concerned about the events of January 6th.
Okay, you signed the letter, though.
Absolutely.
Does that still represent your views?
I signed the letter, Senator. I was concerned about January 6th.
Yeah, and you haven't changed your view at all that the ex-president is unfit for office, reckless and wanton threat to the Constitution?
Under the Judicial Code of Ethics, if that matter were to come before me, it would be inappropriate for me to state my position at this time. So I'm precluded from stating that position.
Well, I'm just trying to figure out if your views changed. I think you've answered my question. I think your answer is you stand by it. You signed it. You stand by it. Is that fair to say? I'm not trying to get how you rule out a case. On a case. I'm just trying to figure out. You signed a letter. I just want to make sure that you haven't changed your views. I think you've answered my question. I think you said you stand by it. Don't let me put words in your mouth. But is that correct? You signed it. You stand by it. Is that fair to say?
It is correct that I signed the letter.
Okay. We'll leave it at that. Thank you, Mr. Chairman.
Thank you, Senator Hawley.
Does that still reflect your views?
Senator, I do want to correct the record. I didn't write the letter. Along with hundreds of other folks, signed on to the letter because we were concerned about the events of January 6th.
Okay, you signed the letter, though.
Absolutely.
Does that still represent your views?
I signed the letter, Senator. I was concerned about January 6th.
Yeah, and you haven't changed your view at all that the ex-president is unfit for office, reckless and wanton threat to the Constitution?
Under the Judicial Code of Ethics, if that matter were to come before me, it would be inappropriate for me to state my position at this time. So I'm precluded from stating that position.
Well, I'm just trying to figure out if your views changed. I think you've answered my question. I think your answer is you stand by it. You signed it. You stand by it. Is that fair to say? I'm not trying to get how you rule out a case. On a case. I'm just trying to figure out. You signed the letter. I just want to make sure that you haven't changed your views. I think you've answered my question. I think you said you stand by it. Don't let me put words in your mouth. But is that correct? You signed it. You stand by it. Is that fair to say?
It is correct that I signed the letter.
Okay. We'll leave it at that. Thank you, Mr. Chairman.
Thank you, Senator Hawley.
I'm trying to understand your answers to this committee. Let's start with the workers' dignity question, because your truthfulness under oath is surely, I notice my friends across the way now are utterly uninterested in any organization you've been a part of. They're suddenly utterly uninterested in things you wrote in the past. They're utterly uninterested in who you give money to. That wasn't the case just a few years ago, but be that as it may, surely they're interested in your truthfulness. I have now counted, just as I've sat here today, 4 separate answers by you, all of them conflicting as to what exactly was your relationship with workers' dignity. So let's just get this nailed down. First of all, did you disclose your relationship with workers' dignity to this committee? Don't look at the chairman, look at me.
I'm not sure that I included that. I don't remember, Senator.
Oh, I think you do. The answer is no. You did not disclose it to this committee. Then you told Senator Grassley, I've never represented that group. Then you told Senator Lee, next, that you had indeed advised them, and that you'd advised them as a member of a legal advisory board. You said 10 years ago, right? Then you told Senator Cruz that, in fact, you told Senator Lee you'd advised them briefly. You told Senator Cruz, actually, you'd advised them for 3 years. Then you told Senator Durbin that it wasn't 10 years ago, it was 15 years ago. So what is it exactly? You didn't disclose your association with this radical group to the committee. You're currently listed now, your own bio lists you as a legal advisor to the Workers' Dignity Group from 2013 to the present. To the present. The Tennessee Bar Association cited your work with this group for your nomination. So what is the story? When did you start working for Workers' Dignity?
Senator, more than a decade ago, for 2 or 3 years, I served on a legal advisory committee or board.
So you gave them legal advice?
We were helping them set up as a nonprofit.
So you represented them. So you lied to Senator Grassley earlier when he explicitly asked you, did you do any legal work? And you said no. In fact, you served on a legal advisory board. That's your testimony now. Correct?
Senator, I served on this board.
On a legal advisory board, correct?
Correct.
Okay. So you lied to Senator Grassley here under oath. What else have you lied about? Workers' Dignity has condemned Israel's ethnic cleansing of Palestine. They have said that Israel is engaged in ethnic cleansing. Do you agree with that?
No, Senator.
How can I believe you? You just lied under oath a moment ago to Senator Grassley. You've lied to us up and down on this committee. I mean, this is a serious problem, Ms. Campbell. I have to say, I've never seen a witness, never, in 5 years in this committee, sit here and lie to us and change the story person to person. Why are you doing it? What is it? Why are you afraid to tell the truth about workers' dignity? Why have you lied to this committee? Why didn't you disclose it? Why did you lie to Senator Grassley? Why have you changed your story every time you're asked?
Senator, I have not lied to you today. I've tried to represent my participation with this group.
What you've done is you've misrepresented your participation with this group. You apologize to Senator Cruz for any confusion. You've created the confusion deliberately. Deliberately. Let's talk about something else that you've created confusion for. The biggest political donation that you've ever made is to Odessa Kelly, this radical candidate who said that members of this committee are Satanists, who endorsed violence. Why did you give money to Odessa Kelly? Over $1,000. I mean, that's not nothing. That may be nothing to you. That's not nothing to most people. Why did you give money, the most money you've ever given, to this person?
Senator, Miss Kelly lives in my neighborhood. She's one of my neighbors.
And you agreed with her views?
No, on those views that you've read, I don't agree with them.
Oh, I haven't read any of them. I'm just asking you. Do you agree with her views? I mean, you gave her more money than anybody else. Your governor, your state senator, your attorney general. You gave her the most.
I do not agree with all of her views, no, Senator.
Well, which ones do you agree with? Can you name one?
Senator, I know that she is my neighbor, and I'm a neighborly person.
Oh, I see. You're a neighborly person. Well, I tell you this. You have represented to this committee that you didn't know what Odessa Kelly said and the frankly outrageous things that she said and did. You said you didn't know anything about workers' dignity. You lied to us about your association with that group. You said you didn't know anything about the Tennessee Immigrant Refugee Rights Coalition, who thanks you personally in their introduction. You said you didn't know anything about that. I mean, either all of these people are liars or you are, Ms. Campbell. It's one or the other. It's quite a pattern. Maybe they all are, but given what you've told us under oath today, I think the answer is you are. And for that reason, you are utterly unqualified to sit on the federal bench.
Senator's time has expired. Thank you, Ms. Campbell, and thank you, Judge Lopez. Your rooms.
Thank you very much.
Senator Kennedy.
I'd like to allow Senator Hawley.
Well, that's very nice of you. Senator Hawley.
Thank you, Senator Kennedy. Thank you, Mr. Chairman. Congratulations to all the nominees. Thanks for being here. Judge Wise, let me just start with you. So as I understand it, you don't think that there really is any clear-cut distinction between male and female as biological categories. Is that correct?
That is not correct.
That's what you wrote.
Sorry, that is not correct.
Well, that's what you wrote. Look, I'm reading your article, your Time Magazine article. Just to be clear, you wrote this while you were a sitting judge, 2017? You were on the bench?
That is correct, after a case I had.
Right. So, interesting choice to be writing opinion pieces about your cases, but in any event, you say that controversial pieces of legislation enacted in the last 2 decades rely on a clear-cut interpretation of sex, what I just asked you, but you say that that's wrong. In fact, gender is an intricate continuum and not 2 tidy boxes. That's what you say. So have you changed your opinion? You just gave me a different answer.
I believe that generally speaking, there are 2 sexes, male and female, that are designated by a doctor at birth, and that applies to the vast majority of people.
But that laws that are based on that distinction are impermissible. That's what you say in this article. Is that correct? That's still your view?
That is not what I say.
Really? You say that if there is, for instance, a law that requires a distinction between male and female in bathrooms, that the judges cannot apply that law with any consistency, can't apply it consistent with equal protection. There are no, what is it? It's virtually impossible for judges to consistently apply a law that permits or prohibits conduct based on whether someone is a man or a woman. So all bathroom laws that require biological sex, that designate bathrooms based on biological sex, are impermissible?
That is not the position that I took in the article.
That's what it says. It's impossible for judges to consistently apply a law that permits or prohibits conduct based on whether someone is a man or a woman. And you specifically cite bathroom laws as an example of this. In fact, you criticize the then Trump administration's designation of gender-based bathrooms. Right? Sounds like you've made up your mind on a lot of things, but I just want to get clear on this because this is an important issue, certainly to people in my state.
It's a very
you
important
think
issue.
you think that bathroom designation, same with locker rooms, I guess, girls' locker rooms impermissible? Biological men have to be permitted into girls' locker rooms?
That is absolutely not what I said in my
That is
article.
absolutely the import and the takeaway of your piece. You suggest at least 3 different constitutional problems with any gender-based laws, including specifically bathroom laws. You write about it. Equal protection violation, due process, void for vagueness. I was making a list as I was reading through. You say that our biological variability means that a 2-bathroom, even 2-sex-based approach is inadequate. Judges cannot apply it. So if Title IX is interpreted to protect women's sports, biological women playing sports with other biological women, it's unconstitutional?
Senator,
That's a yes or no?
I was referring to the 5 babies born a day that doctors have challenges.
No, you wrote an article that is extremely broad that pronounces on a range of issues and pronounces quite definitively. What's this comment at the end of your article about the fact that judges must see the world through a secular lens, and when legislators blur the lines of church and state to enact laws that permit or prohibit conduct based on biological gender as only male or female, they place an impossible burden on the judiciary? What's that mean? That distinctions between male and female are a violation of church and state?
Judges have to be able to administer these laws if the direction, and I have to tell you, I work really hard to get it right, to do exactly what Congress tells me to do and the legislature tells me to do. And as a result, if a doctor finds it difficult to identify at the moment of birth for certain children.
Is a law that distinguishes between male and female a violation of church and state? You say when legislators blur the lines of church and state and enact laws that permit or prohibit conduct based on biological gender as only male and female, they place an impossible burden on the judiciary. So this is a First Amendment violation?
If what you are telling judges is that in order
I'm not telling you anything. I'm reading you your comments, and I am asking you if you are still committed to these, and it sounds like you are. I have to tell you, I think these positions are insane. I think the idea that laws based on the distinction between male and female are a violation of church and state is insane. Totally insane. I think the idea that laws that would say women's locker rooms are protected from biological men, that those are impermissible, that's insane. But that's what you say in this article. You're going to have to recuse yourself in a lot of cases, aren't you? Will you recuse in every case involving biological sex, if you are confirmed?
Senator, respectfully, that is not what the article says.
You have pronounced on all of these issues. Will you recuse yourself in any case involving Title IX, biological sex, challenges to locker rooms, girls' sports, bathroom bills? All of those things are covered in this article that you wrote while you were a sitting judge. Don't you think that was impermissible? Will you recuse? Let's get an answer to that.
Senator, your time is expired.
Will you recuse?
I did not take a position as to those issues that you have raised.
You took a position on all of these things, and your position is insane, totally insane. I will absolutely not vote for you. There's not a world in which I could support you. I can't believe you have been nominated. And if you are confirmed, which I hope will not happen, you absolutely must recuse across all of these cases or stand in violation of the Code of Judicial Conduct. I'm shocked you're sitting here today.
Judge Weiss, you were unable to complete several answers. I'll give you that opportunity now.
Thank you. The thesis of the article, which begins right after the introductory material, that is the first sentence of the third paragraph, makes it absolutely clear that my article had nothing to do with people who are transgendered or gay. It dealt with a narrow issue about babies who are born where doctors are challenged making a determination about sex. And as a sitting judge who has to administer potentially laws where I would have to make such a determination that doctors sometimes find it difficult to do, I think it is critically important. It's important under the Constitution. It's an obligation that we have to treat everyone to have equal protection under law. It is the words that is listed above the entrance to the United States Supreme Court. I actually believe that everybody who is in here cares about all newborn babies and what the circumstances are for all of them. And for those children who eventually become adults, I believe that the legislatures and Congress need to help judges and give a clear indication about what to do in those limited instances. And that is all.
Senator Butler.
Thank you very much, Mr. Chairman. Thanks to all of the nominees for being here today. Congratulations to you. Ms. Gonzalez, if I could just start with you. I was just looking at your resume here. It's very full. You look like someone who's very busy. You're a counsel at a law firm presently, Kaplan, Hecker and Fink. Is that correct?
Yes, Senator, that is correct.
And also a co-director at a civil rights clinic at Howard. Is that correct? Got that right?
That's correct, Senator.
So it doesn't look like to me you have a lot of free time. I imagine that you choose what you invest your time in very carefully. Is that fair to say?
Yes, Senator.
You are also on the board of a group called the Immigrant Justice Corps. Do I have that right?
Yes, Senator.
Let me just ask you about this group that you are a part of, that you're a board of directors, a member of, and the positions they've taken. They've taken a lot of positions. You've taken a lot of positions when it comes to immigration policy, including saying recently that this president's policy, President Biden's recent policy to restrict temporarily some of the flow across our southern border, when on a given day there are multiple thousands of illegal migrants crossing. The president said that after there are multiple thousands on any given day, he would temporarily restrict somewhat the flow, but which, by the way, I think is way too late in the game. He should be doing much more. Your group, however, has been exceptionally critical of this. They have said that any restriction of the flow across the southern border is an abhorrent betrayal of American values and is inhumane. Cruel and inhumane, to be precise. Tell me about that. Is it your view that any enforcement of our immigration law, that if we have anything other than an open border, the policy is cruel, inhumane, and an abhorrent betrayal of American values?
Thank you for the question, Senator. I do not believe that statement to reflect a request for open borders. I have never taken that position. I can tell you, I'm not familiar with that particular statement. I can tell you why I joined the organization, the board of the organization, and it is because I believe in its mission to provide quality counsel to individuals who are going through removal proceedings. It was an idea that was inspired by the late Judge Katzman's study about the efficiencies of providing such counsel to individuals who are going through removal proceedings. And I understand that the organization engages in advocacy and policy, and that if confirmed, my role as a judge would be to put any such advocacy and policy aside.
Well, let me just ask you, I don't mean to interrupt you, but my time is going to tick down here quite quickly. I just want to get clear on this. Is it your position that restrictions on the flow of illegal migrants, just to be, well, let me just ask you this more fundamentally. Do you believe we have a crisis at the southern border?
Senator, I do not believe it is my position to opine on such policy questions. I think those policy questions are very important for
But you're a member
this
of a
body.
board of directors. You're a director at an organization that has taken many such positions. So it seems to me you have taken a position. Your organization certainly has. You represent them. You're a member of that board. You choose your time very carefully, as we established just a moment ago. They say that any restriction on the flow of illegal migrants, I want to be clear about this, illegal migrants is abhorrent. It is a betrayal of American values. It's cruel and inhumane. Is that your position?
Senator, I am not familiar with that specific statement. My
June the 5th,
affiliation,
2024. It's a press release from your organization.
my affiliation with the organization does not commit me to every position it takes
So this
on
is
law
not your
and policy.
position?
No, Senator.
You disagree with this?
Senator, I joined the organization to support its mission to provide counsel to individuals going through removal proceedings.
Okay, let me ask you about that since you bring that up. You have also advocated for providing counsel, in fact, taxpayer-funded counsel, to every asylum seeker at our border. Do you know how many credibility and fear determinations the Customs and Immigration Service performed just in 2023 at the southern border?
No, Senator, I am not aware of that number.
146,000. 146,000 in 2023 alone. So you are in favor of taxpayer funding for attorneys for at least 146,000 illegals. Is that right?
Senator, I was counsel on 2 matters that advocated for the right of counsel for a limited class of non-citizens.
This is your organization that you're a member of the board of directors of. On May 27th, 2022, your organization submitted this official comment to a DHS rule in which you specifically advocated for counsel to be provided at government expense to all asylum seekers. I mean, that's quite a position. So we're talking about hundreds of thousands of people are going to get illegal migrants are going to get government-funded attorneys under your proposal. Is that right? Is that your position?
Senator, any policy position that I have taken in my role as an advocate, I understand that I would be taking an oath to put that aside and to dedicate myself instead to the fair and impartial application of the law, and that is what I commit to you I would do in every case.
Do you still think that detaining people at the border is motivated by, I'm quoting now, motivated by financial incentives and political calculations rather than any legitimate or evidence-based purpose?
Senator, I'm not familiar with that statement.
Well, that's from another statement made by your organization in September 22nd, 2021. Let me just say it again. Detaining people at the border is motivated by financial incentives and political calculations rather than any legitimate or evidence-based purpose. That just seems crazy to me, to say that enforcing our laws and detaining folks who are here illegally, crossing illegally, is motivated solely by financial incentives and political calculations. Do you agree with that?
Senator, I joined the organization to support its mission to provide counsel.
Yeah, I've heard that answer, but do you agree with this? You're a member of the board of directors of this organization that frankly has taken crazy positions over and over. I'm just wondering if you agree with these positions. So this is just a yes or a no. Do you agree that detaining people at the border is motivated solely by financial incentives and political calculations?
Senator, I'm not familiar with that position.
But do you agree with it? It's from your organization that you sit on the board of directors of. Just do you agree with it? Yes or no?
Senator, I'm not familiar with the context.
Do you agree with it? You're not going to answer my question, sounds like.
Senator,
You just say yes if you agree. That's fine, but say no if you don't. I mean, I'd like a yes or a no answer. It's a simple question. You're on the board of directors. They've issued this. Do you agree? Yes or no?
Senator, I joined the organization to support its mission.
Goodness. This is disappointing. I don't understand why why won't you answer me? Are you afraid of the answer that won't be popular? I mean, why are you distancing yourself from it now? Aren't you still a member of this organization? You're still on the board, aren't you?
Yes, Senator, I still sit on the board.
Okay. Well, so you don't agree with any of these positions? You won't say now whether you agree or not. Is it because they're so radical?
Senator, my personal position on any policy issue would play no role in the job that I would perform as a judge if I were to be confirmed.
You've also written a paper in which you say that you don't think police ought to enforce traffic laws because it may lead to inequity. Do you remember that paper from 2023?
Yes, Senator.
Why is that? You don't want police to enforce traffic laws? I mean, it just seems to me, I'm having trouble following your positions here. You don't want the immigration laws to be enforced. You apparently think that any detention of illegals at the border is motivated by political calculations and is illegitimate, and you don't want police to be enforcing traffic laws. But you want to be a judge. How's this going to work?
Senator, the piece that you are citing documented efforts by cities along with police departments, and in some cases actually led by police departments, to move enforcement of things like hanging an air freshener from a rear view mirror to, for example, ticket by mail or parking enforcement, which would in turn free up police resources to focus on more serious enforcement.
I'm almost done, Mr. Chairman. Not just that, though. I mean, I encourage people to read the paper. In fact, I've got it right here. It's 14 pages. Mr. Chairman, I'd ask consent to enter into the record the road to driving equality. Frankly, it is full of positions that I think are just nuts. I mean, saying that things like running traffic lights, stop signs, these things can't be enforced, that the police ought to get out of enforcement of traffic laws altogether. I mean, I don't understand it. It sounds like to me you don't want enforcement at the border, you don't want enforcement of our traffic laws, you don't want police enforcement in our cities. I just question whether that is a good set of perspectives to be a judge whose job will be to enforce the law. Thank you, Mr. Chairman.